Good morning, good afternoon, good evening, depending on your time and depending when you're going to be seeing this video. It's your brother, your boy, Cos Reps Corner. Like I always tell you guys, it's my corner, it's your corner, and it's our corner.
I don't wanna fall in love. I just wanna have some fun, yeah. I don't wanna fall in love.
Well, the Kano judgment, there is so much confusion about that judgment. And I think the court shouldn't have even gone into that matter in the first place. As to the effect on Abia, the court said it in that judgment that there is no way the court could give orders and could make a pronouncement on what happened in Abia. He said it. The judge was referring to the court's territorial jurisdiction. That matter is actually a pre-election matter. When you are talking about the qualification of a person to contest the election, what they were alleging and their prayer to the court was that they were saying that the party did not submit a register of members, and because it did not submit, and that is a mandatory provision in section 77, that because we did not submit, that means that the votes scored by our candidates at the election are invalid. But that is never correct. That section of the law never pronounced about the punishment for not submitting register of members. But we have to make it clear that the party submitted our register, we submitted the hard copy, we submitted the electronic copy of the membership register as when due, and that our candidates are qualified, and in the first place, if you want to challenge the outcome of a primaries and the submission of a party's name to INEC, it's a pre-election matter, and you ought to have done that within 14 days of the occurrence of the event. These events occurred since last year, and we submitted the names of our candidate for governorship and members of the House of Assembly since July 22, and the final list was published on October 4 last year. If you look at the time frame between then and when that matter was filed, this matter in Kano was filed on May 11. It will surprise you that this matter was filed May 11 and judgment delivered May 19. Look at the speech. So it is clear that there is something went behind. We were never served as a political party. And one of the things that we have to be confident that judgment can never affect any of our members that have been elected. The reason is their names were not on that process. The court was actually just going back and forth. The court said it, that the members elect, the governor elect in Abia, and the members elect were not before the court. But the court must also have said that even the members in Kano were not before the court. The defendants in that matter were INEC and Labour Party. And the truth is that Labour Party was never served. We are here in the National Secretariat. If you want service on a party, on a political party, should be at the national headquarters of the party and should be service on the principal officer of that party. Nothing of that happened. But we knew what happened. And, there are some suspended national officers of the party who have been hired by the APC to scuttle the progress of the party, to try as much as possible and undermine the interests of the party, because they have seen the movement in Nigeria today, that the Nigerian people, especially the young people in Nigeria, have realized their potentials and will no longer accept to be put down. They have decided that their vision is being promoted by the Labour Party. They have seen that, they are no longer going to allow themselves to be dictated to. People are not happy about this. The people who believe that they have to give you power in order to attain power. The people who believe that they own the country. But we are saying nobody owns this country. The generality of the Nigerians own this country, and they have to take their own destiny in their own hands. People have identified with the vision of the Labour Party, and that's why they are doing all this. These suspended national officers went to Kano to file this matter and misled the court about what actually transpired, and tried to get a judgment behind the party. But you can see from that judgment, it's clear that judgment cannot bind anybody. And that judgment, even the court itself said it. If you look at those prayers that they have made, it was not what the law said. It was their mere wishful thinking. It was their evil plot to actually bring the party down. And that is what you read. But even as the layman is confused about that judgment, Even lawyer choose, they cannot make head or tail of it. And if the judge has not said anything specific, the judge has only reiterated the wishful thinking of these hirelings, and that is what is there. So nobody should take it too seriously. If we are going to appeal that judgment, it is only to clear the confusion, not because the judgment can affect any of our members elect. Our members elect are going to be sworn in as from May 29, and we are good to go. Yeah. That the judge couldn't have even entertained it at all. The matter is statute bad. You have to bring an action that has to do with the qualification of somebody to contest an election. You bring the action within 14 days. That is section 285 of the Constitution. So section 285 of section 9 says you bring the action within 14 days of the occurrence of the event. And that just means that within 14 days that person emerged from the primaries. And even if you want to claim that you did not know the day you emerged, at least that name was published. INEC published the name that this is the candidate of Labour Party for this election. From that day, that you think that person was not qualified to have emerged as candidate, you ought to have brought the action. So the court is not, it does not have power to attend the matter because the matter is statute bad and shouldn't have entertained it in the first place. And if the court wants to say, okay, it's a post-election matter, then where do you take a post-election matter? If somebody has emerged as an elected governor or an elected member of the House of Rep or a senator elect or a House of Assembly elect, there are tribunals set up for that purpose. And if you want to challenge the victory of that person, you go to that tribunal. And you go to the specific tribunal. For example, there is a governorship election tribunal in Abia State that will handle cases that are arising from the election of Alex Oti as the governor of Abia State. And if you want to challenge, and there are also tribunals set up for National Assembly, National and State Assembly tribunal set up for that purpose. So you have to go to the, and even when you go to that purpose, that is when you make your case. So it is not to go to a court in Kano. And the court, you see, these are some of the handiwork of the suspended former national officers of the party who have sold their soul to the APC and are ready to do their bidding. They are just collecting money from them and trying to, but they cannot succeed. We are alert. We know. You know, before we knew them and we knew what they could do. And we are really ready because this is a project we are serving Nigerian people, and we are determined to do our best in order to keep the faith, in order to assure them that they have put their trust in the party. The party will continue to work hard in order to ensure the emancipation of the Nigerian masses for the trust they have in the party, and that is our mission. And we are focused. We are not going to allow ourselves to be deterred or be distracted by the efforts of these people, because we are sure those efforts will become futile, because we are convinced of the solemnity and sureness of the triumph of good over evil. There is no way evil can prevail.